Hello, everyone, and welcome to the IR Global podcast. IR Global is the largest international professional services network. I'm your host, Jennifer Riggins, and today we're talking about the result of that network of friendship and business collaboration between Kyle Broadhurst and Nevin Sanli, diving into the unfortunate but sometimes inevitable anti-friendship, the inevitable shareholder disputes around company valuation, friction, not fun. More than when my kids' friends, well, you're not my friend anymore, they say in a more legal sense of the word. So I want to invite you each to introduce yourself. Nevin, would you like to go first?
Sure. I'm Nevin Sanli with Sanli Pastore Hill. We've been established in 1992, so we're over 33 years in business, and our expertise is business valuations for shareholder disputes, for uh, breach of contract matters. We value loss of business value, lost profits, and we testify in court as expert witnesses, and we provide other financial opinions and expert opinions in high scrutiny, bet the farm type situations.
Okay, thank you. Kyle, same question. Who are you?
Yeah, my name is Kyle Broadhurst. I'm the managing partner of Broadhurst LLC. It's a law firm operating in the Cayman Islands. We are a dispute focused firm, a dispute resolution focused firm. We get involved in all kinds of different issues on behalf of shareholders or people interested in companies, all from amicable to contentious. We can talk about those sort of different things in a moment, I think, when we get a little further into it.
Okay, thank you both. Who should be listening to this? Obviously, not maybe obviously, but in the world of law, there are different jurisdictions and there are different positions that could be clients. So who would be benefiting from listening to this?
Yeah, well, so that probably dives well into it. So I think there's a lot of different issues that can arise between shareholders and when valuations become necessary. You have situations where it can be amicable. You can have somebody looking to purchase an interest in a company or maybe an outgoing shareholder. And then you can have all kinds of different contentious disputes. So you can have perhaps a dispute concerning the acquisition of the company. Where if somebody wasn't transferred shares and you're in a situation where they can no longer be given the shares, so you're trying to value what that was worth. You can have divorce proceedings, obviously where couples separate and you're trying to decide what the interest was worth. You can have mergers or consolidation. Here in the Cayman Islands, we have specific proceedings that can arise where a company might be merging or consolidating and a shareholder has made a proposal, but they're not happy with that proposal. And so there's a procedure here whereby they can ask for the value of their interest to be assessed. And then you have sort of the shareholder in distress or a minority shareholder who's in a situation where they don't have control of a company, maybe something's happening that's untoward. And in certain circumstances, that shareholder, instead of having the company wound up, can apply effectively to have their interest purchased.
Oh, wow. So there's a lot of different people who could listen to this conversation, whether you're in these awkward situations or thinking you might be, or thinking you might be the cause of them, right?
That's true. Yeah.
So, Kyle, let's start out by laying out the remedies available from a legal perspective, because it can be
Yeah.
amicable, court-based, etc.
Yeah, sure. I mean, I think taking aside, the situations where I said it was amicable. I mean, obviously there's a situation where Nevin would be engaged just to do a sort of standard evaluation of the company. And if it's amicable, then there's not normally issues with respect to information being provided. But where it can be more interesting is you can have situations where, I gave the example where there's a merger or consolidation. So under our law here in Cayman, Section 238 of the Companies Law allows for our court process whereby the minority shareholder's interest will be acquired for a value. And you get into all kinds of different issues about sort of how that should be assessed, what the fair value is, what the mechanism to assess it is, whether there should be a minority discount or not, the valuation date for the company. So those all can be legal questions, but then they all factor into the sort of issues that Nevin will be wrestling with when trying to arrive at a value.
Okay, absolutely. And for those listening, if you're interested specifically in doing business in the Cayman Islands and specifically about insolvency and creditor rights in the Cayman Islands, wow, Kyle and I did a podcast 4 years ago about that. So you'll see that in your podcast feed in case you want just basically an excuse to visit Kyle's beautiful home country. Uh, so now to flip to the other side of it, Nevin, you're a lawyer, but you're, I believe, or are you more in the finance space? Like, how do you decide on these common valuation models and other considerations when
Yeah.
valuing, what is the term? A company.
Valuing, yeah, but I'm not a lawyer. So I'm an economist and a financial expert by training.
Yeah.
And I get involved in the situations for the purposes that Kyle mentioned, is that the business has to be valued. Now, if the situation is not contentious, it's a lot easier. The parties cooperate, but we still have to bring a valuation report that will withstand scrutiny from both parties and their respective attorneys. So typically, the corporation has an attorney, the shareholders have their respective attorneys in this situation, and everyone has to agree on the valuation. So the report has to be quite substantive and well-sourced, documented, and even-handed. And it is important to bring an expert that has the credentials, the expertise, the experience to be respected by all the parties that are involved in the situation. Now, the data value is something very important. Sometimes the parties may disagree on that. The definition of fair market value or fair value, sometimes it's not even mentioned in the articles of incorporation. Other times it is, but vaguely. And sometimes it's mentioned so precisely that it makes everyone's job easier because they consulted people like me to put in a clause in there on how to do the valuation, for example. So it can be all of those situations that occur. And then even though it's amicable, the party may disagree that a discount should be taken for lack of control and marketability. And sometimes the agreement may say something like all applicable discounts should be taken. And other times the agreement says fair market value should be applied, and that implies that discounts be taken because a fair market value is the market price somebody would pay out there for, let's say, buying out a minority interest. And that would be subject to lack of the discounts or lack of control and marketability. And then Kyle mentioned it intentionally, I believe, fair value. Fair value means that typically no discount should be applied. It should be the valuation should be as if it was sold in the open market in its entirety, and the shareholder should receive his or her pro rata share of the purchase price, regardless of discounts. So it can get pretty complicated. And just to get over these wranglings, you're wrestling with these issues amicably, in a sparring mode more than in a real fight mode. But you still have to settle these issues before you get to actually doing the work and bringing propositions to the parties as to where we're going with this.
Yeah, and I'm not really sure if I understand the difference between fair market value and or what's fair and what's market value, because do you have to try to sell something first and creates the value, or you can't sell it because you can't set the amount you're selling it for?
Well, with fair value, it's the price that a company would fetch, assuming you sell it in the open market in its entirety.
How would you know that though, especially in these very changing times?
Because you hire a valuation firm to estimate that.
Of course.
Okay.
Yeah.
And so that valuation tends to maximize the price it would fetch on the open market, but with reasonable consideration for the weaknesses of the company and the possibilities that there may not be that many buyers because it may be a highly specialized company that requires engineers to run it, for example.
Or what about an economic downturn times?
Exactly. It
It's in a
could,
country that
yeah.
is in war or something, or.
Yeah, so it's a good point, Jennifer, and you picked up on a nuance that happens a lot here in Cayman. So under the Section 238 proceedings, you'll see that the court doesn't say there's no fixed model. It'll look at what the experts have different approaches to these various different questions, and not necessarily one is right for every single situation. And that's the way the court looks at it. So it's important when you're having your expert prepare the report that they've been very clear in the way the models, why they're using the model they use and how they apply it. And because at the end of the day, often what's the case is you'll have competing experts with two different reports and two different ideas about how something, obviously one's pressing for a higher value and one's a lower value, and the two parties are, for their own purposes, want the result. And so, yeah, and what happens here with the court is it'll actually look at both methodologies that are used, and then it actually can pick and choose. It's not doesn't necessarily have to be one takes all, but often one will be preferred.
Okay, or it could be something where they take an average, or they pick.
Yeah, there's a lot of flexibility because of what we're talking about. I mean, you're talking about valuing a company, and of course that sounds simple. It's like, but it's how long's a piece of string kind of problem when you start really looking at what's its future prospects, and and when are you valuing it, and and then the concept, I think we touched on it a moment, the minority discount concept. If you don't have a controlling interest in the company, does that mean you're not really, your 33% isn't really worth 33%, or is it worth something less or more? Well, less. But so yeah, you get on all these sort of issues which are complicated, and this is why you have this relationship between the attorneys and someone like Nevin, because he's got the capacity to provide this in a form that even I'll have to argue these things, but it'll be based on his expert evidence that I would be doing so. Yeah. So that's how we proceed.
Kyle, does it happen that sometimes you have to go to court and ask the judge for declaratory relief as to which method should prevail because the parties are fighting over it, which definition should be used for what?
Yeah, often what happens is that the methodology of how the valuations be done is not necessarily determined by the court in advance. Often the case, parties will have, and it can differ depending on what we're talking about and which circumstance we're in the court. But generally, the order that the court's going to make is that the company is to be valued. And sometimes you might have some more particulars than that, but it'll be generally pretty general. And then you'll have the duty obviously for disclosure so that the evaluators can get all the different information they need. And then it'll be up to the evaluator to decide this precise methodology, or sometimes they'll give a report with different methodologies and different values based upon those methodologies. So more often than not, it's going to be a case where there's going to be some leeway in terms of how the evaluator approaches it, and it's going to be their justification for that approach. It's going to be important for the judge to understand why he or she should go with one particular value or another.
And then you had mentioned minority shareholders.
Yeah.
So how does this factor in, I assume, in private companies, because public companies, we kind of know the value, right? But when do you need a valuation when there's this minority shareholder arguments?
Yeah. Yeah. So what happens in Cayman is that it can be very difficult if you're in a minority shareholding, because there's not any obvious relief for you because you're in a situation where you don't have control of the company. And so in more extreme circumstances where you have one shareholder being treated prejudicially, or the company effectively is not properly operating, its substratum's broken down, or if you had sort of like what's called a quasi partnership, where although it's a shareholding that was really more like a partnership. In these kind of scenarios, you can apply to the court, and what you're actually doing is you're petitioning to wind up the company or to put the company in liquidation on one of those grounds. And if the court thinks it's just and equitable that's the test, for the company to be wound up, instead of winding it up, it can make an order for that minority interest shares to be purchased. And in which case, then you're into a valuation and you're into trying to figure out how that valuation should be done.
And the minority situation is very, very challenging for the parties because the reality is that a minority interest in a privately held company is impossible to sell out there in the market.
Oh, why not? Why?
Well, yes, good question, and because if I'm a buyer, why would I buy a 1/3 interest in a company that Kyle runs and owns 66% of, and has complete control of operations, of distributions of cash flows, of setting his own bonuses, or setting his own salary, and setting his own perks? And as a minority owner, since I don't have any control, it's very difficult, if not impossible, to sell this minority share to a third party.
Oh.
Therefore, those shares are discounted substantially for lack of control and marketability. The
Hmm.
control part is I can't even call, let's say that Kyle's company makes high-end flashlights. I can't even call Kyle and ask him to deliver a box of flashlights for my son's birthday so I can give one to the kids. I can't, even though I'm a third shareholder, to all the kids that will attend, because Kyle will say, well, you're going to have to pay for those. We just can't deliver them, or go buy them at Home Depot or someplace, go buy them at a store. So that's one reason.
Not very nice of me, but yeah, okay.
Yeah, so you just can't buy. I mean, Kyle's a nice guy. He's probably gonna be nice and
Look,
say,
you're
look,
getting the flashlights. I'm sending them to you, right? So,
but generally speaking, you don't have that authority. And second is that I can't argue anything that Kyle does because he has 66%. So for example, he can distribute in the form of bonuses all of the profits and not give me any dividends.
But didn't you know this going into it? You bought 33% of the
Well,
company.
you may have started it. You didn't buy it. It's no one usually buys 33%. They started together. And because Kyle says, look, I'm going to put 66% of the cash, I have the expertise, and I'm going to run the company. You're going to be the controller or the CFO, and you're going to have 33%. We're going to work together. And 15 years later, the CFO says, well, it's time for me to retire, or I don't like the way you run the company, so I'm leaving and I want you to buy me out. Now,
yeah.
the doors are shut on that minority shareholder. He or she can't come into the office
Oh,
and
wow.
can't get a salary, and they're gonna use personal after-tax money to fight this, whereas Kyle, as the CEO,
Oh.
can use pre-tax money and deduct it, can use the corporate money.
Mm.
Yeah, and this gets to be a complicated problem, right? Because using the flashlight issue, that wouldn't be enough to run around and say the company needs to be thrown in liquidation. That would be me, although not very nice, but me perfectly exercising my rights to not share that. Now, so you get into a situation of what kind of activity is enough, and so you have to have significant oppression or the some sort of example where the substratum of the company has broken down. So in other words, it's it was intended to manufacture flashlights, but it doesn't do that anymore. In fact, it's not doing anything anymore. So those kind of examples, that's when you can go to court. It does bring into another really related but unrelated to what we're talking about right now. Well, actually, sorry, it is related. Actually, I think about it. Just the need for shareholders agreements to exist very early on in the process. And normally a good shareholders agreement is going to say exactly what's going to happen when, use this example, the CEO or CFO leaves the business with their shareholding and how that's going to be valued. And sometimes it can be very specific as to exactly the process for valuation. And that can be very helpful because the problem is that often the law will not have a remedy for somebody who gets into that situation because they went in with their eyes wide open, in the sense that, and everybody's behaving in accordance with the law. It's unfortunate, but there isn't really a peg to hang on to there to complain, really, in the sense that it's you don't like it, but it's not against the law.
In some instances, one of the remedies to the minority shareholder is to ascertain or to claim that the company is mismanaged, that the CEO hired family members, but they're not working, and they receive salaries. The son who is in college receives a salary, never stepped foot in the company. And that Kyle bought himself a private jet with the company money.
It's Kyle.
And
that was legitimate. That was legitimate.
And that jet is not neat for the business because most of the company's clients are here locally and the products are distributed by large distributors, et cetera, et cetera. And so the examples can be extensive. It could be a car collection that is purchased with company money. It could be the ski chalet. It could be the yacht, the sailing boat. Or I had this example, the CEO was running car races and justified it that as that it's marketing for the company because he had the company logo on it. The problem is it was the type of car races nobody watches, that doesn't have any TV audience, doesn't have any radio coverage, nothing, except to have about 5,000 people watch it, in person. So, there are all sorts of things like that that depress the profits of the company that is available to distribute to shareholders that are not legitimate business expenses. But that is an expensive battle to prove that. And Kyle, I'll let you take over from there.
Well, yeah, I mean, obviously, if there's malfeasance, though, then that's another reason. If you have directors regularly breaching their duties, then that's another basis. Maybe you're seeking for winding up. Another remedy that might show up there is you can have derivative actions that can, if so, what that is essentially it's an action being taken through the shareholder on behalf of the company where its directors are improperly acting. And so sometimes you can have claims that are brought that way. But all of these things, as Nevin's alluding to, are not simple and they're not cheap. So it can be a really complicated measure. So these issues that we're talking about are complex. And it is a situation where, I said a moment ago, the more you can do at the front end of these things to have them properly papered is really a good idea to try to avoid these issues later.
Yeah, absolutely. So as soon as possible, and I guess it gets more complex as you deal with crossing borders and people in different countries. And that's kind of how we ended up here today, because it is unusual that we have two guests on the pod, especially two guests from two different firms or companies. So do you want to, Kyle, Nevin, tell us about how you two met and how you work across? Originally, I'd written oceans, but I would say it's one ocean.
Yeah. So, well, Nevin and I had the privilege of meeting. I'm trying to remember the first time we met, Nevin. It was a couple years back now, I think. And then, as it happens, we've had a matter now that we've been able to, or that we're currently working on, which is great. And it's always nice. It's one of the things with our network is that here in Cayman, we have issues all the time that we have clients that need help overseas. And at the same time, there's a lot of people overseas that have interests here in Cayman. So, we find the network quite useful for that regard. In this particular instance, it's helpful to have external expertise, which we can use. So this is why we're able to use Nevin's firm here as an expert for us in assessing the value of a company.
How does that work? Because I guess Nevin is jurisdictioned to make up a verb in the US, not in Cayman Islands. So how does that work?
Well, look, so in the Cayman Islands, when you're talking about the kind of expertise that Nevin has, it's sort of universal in the sense that he has all the qualifications to be called as an expert here. So in Cayman, we're quite open generally to foreign qualifications, largely because of, well, we're small nation, right? So it's not an issue in that regard.
And we're based in LA. We have offices like headquartered in Los Angeles, but we have offices in several US cities and also overseas. But mostly the business valuation profession is worldwide. For example, I've valued companies in Nepal, I've valued companies in England and France, Spain, South America, all over the world. And so because it is a technical expertise, not a legal expertise that may have some jurisdictional limitations, we are not bound by the local of the offices we have. And so that enabled us to work in the Cayman Islands and other jurisdictions, like I'm working on a matter in Puerto Rico as well, and also with an IR Global member. And when Kyle and I met, we first met, I recall, I think it may have been Boston, Kyle,
Good
the
one, yeah.
Boston conference. And I met with Rich and Kate from his office. And, you know, I find myself go into a rooftop in Boston and then see Kate and Rich there. And then we sit down and talk. And we had already gotten along well before. We talked several times. Then we had dinner all together at a table at the conference. And we really, you know, kind of bonded and felt comfortable with each other. And so Kyle had told me, you know, I may have something for you. It may happen. And then, you know, a few months later, 6 months to a year later, we started working together. And I think that it's a testimonial to the strength of the networking and of attending conferences and spending time with people, but also to be intentional, to intent on working together and finding opportunities to help each other. I think is part of the process. The other thing, we're part of a community, and we owe it to each other to do the best we can and to do a great work, because it's gonna spread through the community, and that is also our strength.
And then you can sacrifice yourself, Nevin, if you have to, you know, go to the Cayman Islands to be
Uh,
a witness. You can, you.
it'll be Yes, it'll be so hard to go to the Cayman Islands and time over there. Yeah.
I don't want to be difficult, but that's the only way you're getting those flashlights.
Yes, because again, flashlights are a common goodie bag gift at children's birthday activity.
Yeah.
Oh, thank you so much, Nevin and Kyle. This was a great conversation. I'm sure the listeners want to contact you through the IR Global Network, or we'll put it in the, as John Green would say, the doobly-doo at the bottom of the description, if they want to continue this conversation, to preferably create a shareholder agreement ahead of starting a business, but if not, create a shareholder agreement ahead of disputes.
Yeah, fair enough. Fair enough. All right. Thank you very much. Appreciate it.
Thank you so much.
And
And
listeners,
Kyle, great to see you again. And thank you for the great questions.
Yeah.
All right.
great.
Take care. Bye-bye.
Thank you so much. And listeners, if this is something you think someone can use, please do share it.
All right. Thank you. Take care. Bye-bye.